Just like with any business, where there has to be a cause. And as a result of that cause, there will be a system and a team to execute that cause. Everything that exists is the same way. When people ask for templates, when people ask certain questions regarding intricacies of things, what they intend to figure out is the system behind what they're facing, or how they themselves can create a system to be able to perpetuate their own cause. This thing called the court system, and the United States people know of, is based off of a cause, that being financial interest by way of commerce. And the business is the medium to enforce it. Business is not some college degree or some certificate that says you're a master's or PhD in something. Business is not your mere creation of an LLC or a sole corp or a trust. The business itself is the system and the team put together to perpetuate the cause and the intent. That's what the business is. These people that everyone speak of, whether it be their military arms, called the police, marshal, sheriff, whatever it is, or the court, lets you know it's a system. The way you know the court is a system is through the circuit. Circuit is just a channel of where energy could pass through to satisfy an intent. Same thing applies with district. The court system, there's a system within it, from the clerk to the people who protect the court, called the sheriffs or the marshal, to the different types of judges, to different types of attorneys, and the different types of district of the attorneys, and how they contract with the county, and how they rent the offices out, and how they monetize things, and how they determine whether they should look at it from a judicial perspective or from a strictly commercial perspective. How they probe for competence through doublespeak and hypnosis. All that constitutes the system and the teams of people to perpetuate the intent of that business, their cause. Just as much as you will go to a hospital, a business, corporate building, there's a system that holds it together. There's a team that holds it together. No different than these things that people are facing with tax, with child support, any given venue, and they adjudicate claims against you. It is a system with teams that come together to bring the intent that the system is created for. The question that ought to be posed to oneself, if one intends to do anything, one way or the other, whereby the other parties are to be interfaced with, is, do you have a system? And what is your cause? Just like business, you have to remove your subjective feelings of what you think your cause is. Ask yourself and question yourself what your cause is. And the odds are, the first response that one gives themselves as to what their cause is usually actually not the core of what your cause is. So one must question themselves, what is their cause? Because from understanding and comprehending what your cause is, you'll be able to create a system and be able to get a team, no matter how small or how big, together in order to perpetuate that cause. And you will truly comprehend how all this is commerce and business. Beyond one's need to just say they're doing on commerce, they monetize this, the banks or a bank account, they're fraud. It's a system backed by a team to perpetuate a specific cause on their end. And so must you do the exact same thing. One of the issues most people face, without first questioning themselves as to what their cause is competency. And whenever you fail to have a system and a cause, best backed by a team, what you will realize is one's lack of incompetence will cause their system to modify itself in an effective way to counter any potential outcome. Because if one is not clear what their cause is and they're just loosely acting, the other people who are clear of what their cause is will be able to have a foresight as to what your potential true cause is before you figure it out. A perfect example is the court system, which is used as a medium to basically attain people. Attain is just another fancy word to enslave someone. That's what it means. When they say no bill of attainder shall be passed, that's basically certificates and contracts regarding slavery. That's really all it means when it comes down to it. And what is done in these court systems is bills of attainders are issued in order to perpetuate their own cause by using a system, a team, and it's that simple. One of them is this thing called the United States Courts. Article 3, Section 1 of the United States Constitution. The judicial power of the United States, named the courts, shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. Article 1 of this Constitution speaks about the legislative branch. Article 3 specifically speaks about the judicial branch. And within the judicial branch, it speaks about one court where judicial power is vested in. And then, in addition to that, it speaks about inferior court based on Congress, aka legislature. So when you hear people speak of Article 1 courts, what they're referring to are the other inferior courts that could be granted the ability to do certain things, meaning through operation of law to enforce things in harmony with constitutional principles preserved in the Bill of Rights on a state and federal level. If it's not in harmony, it's dead. Nothing more to it. But rather than going into the legislative courts, let's go to the judicial one that is succinct as having judicial power within the United States that they bring you to. And if you want to create restitution, if you're not doing it by the power of the people with other equitable relief outside of the formality of courts, or if you see the necessity of implementing certain operation of law and the formality of courts, it's still important for you to comprehend this. Judicial power of the United States is vested in one Supreme Court because Supreme Courts have the final say. And then in order to kind of eliminate the load and workload, these inferior courts are created, like the circuit system, which you will now go through appeal to get to the Supreme Court. You see the hierarchy of how that system is established. Is there more? Yes, there's always more. But generally speaking, there it is. But nonetheless, these inferior courts do not have judicial power. So if anything is done that abrogates you in your essence one way or another, Supreme Court has a final say because in truth, it's the only one with judicial power. So given this fact within the system and a team that's organized for a specific cause, many people try to go in there and speak up on their behalf without much competence. One will lack competence without a cause of their own. You have to question yourself. Even when you think you have a cause, question that cause. From there, you will see the system that you need to create and interface it properly with their system. It's all about systems. It's really that simple. It's all about systems. On that same note of system, where the Supreme Court being the only court that can hear things, are you aware that people who do not use attorneys actually are not allowed to introduce oral evidence in Supreme Court? Why? Because of the flurry of incompetence of people who fail to comprehend that a system is important with whatever they're doing and whatever they're doing. And one cannot formulate a system with what they're doing and interface it with another system if they do not comprehend their own cause and intent. Without much thinking, but with much feeling, which is good and fine. But business and commerce does not care about how you feel. But without much thinking, people think they have cause. People think freedom is their cause. But there's a lot more to it that people need to question themselves, or else it would end up like this. Remember, the Supreme Court is the only court that actually has judicial power one way or the other on a judicial level. Now, there are other administrative courts and arbitration courts, one way or the other, either through mediation or through executive departments, or for international relations, or for specific things like taxation, all that. So now say a circumstance very important comes in, whereby it affects the public at large and the generation to come. It affects the flow and ebbs of all the other legislature in every state. and all the other inferior courts in every state based on incorporation doctrine. And you somehow end up getting to the Supreme Court, and you know for a fact that you got it in your bag. And all it requires is some intricacy for you to stand on it and say or do certain things, lie beyond what's written in black and white. Did you know that that ability is barred? Because if you really want to make any serious change that will reflect on a congressional level and state and federal level, if you're not coming in as one of the people or taking it to Supreme Court level, either on the state or federal level, it's just going to be dealt with by instances, meaning we're just going to go along with it as it comes, and it's not going to be permanent and solid. On the note of not having a system through competency and not understanding and comprehending one's cause, do you know that they've done everything they can in the past? According to the rule of the Supreme Court, then this is the rule that the Supreme Court abides by beyond the federal rules of evidence and the federal rules of civil procedure, or the appellate's one in a criminal or not. Rule 28, oral argument. We're going to section 8. Oral arguments may be presented only by members of the bar of this court. Attorneys who are not members of the bar of this court may make a motion to argue pro hoc vici, which we went over in the past. It's basically where someone who is outside the business jurisdiction of one area basically gets a permission, like you have an LLC from another state and then you just transfer it by filling out certain forms on a state level or an county level to transfer that LLC as a foreign LLC. Or you would do decanting of trust, where you would transfer some asset from one trust to another, regardless of whether situs is, regardless of what type of trust it is. The same concept applies with pro hoc vici, which is just a form of doing business as within this specific court venue, because each court venue that any given attorney is allowed to practice in is the specific courts that holds them harmless by way of their bar attorney card, not the international standard lawyer number, but the bar number issued by the British Accreditation Registry membership, tied to the county, which they have the district attorney so-and-so, and all that being different from the international standard lawyer number. But nonetheless, pro hoc vici is just a permission to do business. And they're letting you know that regardless of whether you're an attorney doing business in the Supreme Court or not, you're fine. You're able to speak up. And the only one that can invoke due process of speaking up for themselves are just attorneys only. Look into a man called Sam Sloan, SAM space SLOAN. The last man or woman that was able to enforce due process, stand up for themselves and speak up for themselves in the Supreme Court was in the year 1978. 1978. How come no one speaks of this? All these people speaking of improper persona, having one status, being able to do one thing or the other. If you really want to make change in the ebbs and flow of life, certain things would have to move either privately outside of these venues. And you will find out that there are certain aspects of life whereby you would have to work the dynamics of these same courts that everyone hates and run away from. Granted, certain things can be enforced outside of it, but I'm telling you, there are certain things that you and everyone else will have to come together and comprehend the dynamics of how these things work. And they are slowly changing their system in preparation of that time. You might not see it now, but that time is going to come where the necessity will exist. And they are slowly but gently, decades after decades, creating their system in a manner whereby it will make it difficult for people coming in at one point or the other. Remember, the art of war allows you to see ahead of time and plan ahead of time and hide things, keep things secret, because omission of information is equivalent to basically going into the war field blind, and information is how any battle or war is won. So remedies exist outside of these formalities, but once again, there are other things that is yet to come to the forefront of people's minds that they will need to work its dynamic on a Supreme Court level. And just as a future reference, here's one of them. Here's another form of public notice regarding the same. They tell you, not necessarily telling you, hey, people, you need to pay attention to this because this is important. If you haven't joined my Patreon, I'm inviting you to do so. We speak about a lot over there that we don't speak of on YouTube, simply because it's usually more confidential and in some ways quite advanced. We speak a lot about restitution, speak about things financial related, we speak of tort, we speak about the details of how copyright is enforced, how and why of the discharge, things spiritual nature, speak about how banks work, and other things about how to remain private, how to pierce their attempt at being private, how to use certain tools that a lot of people don't know relating to case audits and court tax transcripts. We speak about the details of settlements. We speak about child support. We speak of business things relating to the states. We speak about discharge. We speak of trust matters, how it's used, and much, much more details. So come on over. Come join us. Only lawyers now can argue before Supreme Court. You must be a lawyer to argue before the Supreme Court. Thought that already was the case? Meaning, you think that's a normal thing that occurred before? No, not really. It wasn't until Monday when the Supreme Court revised its 80-page rule book for the first time since 2010. This public notice was given July 1st, 2013. The update covers items such as filing deadlines, but also add Rule 28.8. They're perfecting their system because of other people's incompetence taking stuff on the Supreme Court level, not having a system to do things. And from not having a system to do things, but the will and the fire is there, they looked ahead and realized the potential aspect of how what that man failed to do and complete, how it could come back and bite them in the butt. It's like waging a war on someone pillaging their village. Would you leave the little child who is male, that little 2, 3, 4-year-old male, would you leave him alive? Because chances are in the future, if that child, man or woman, realizes what you did to them, when they grow up, they will gather, come back, and slit your head off. So whenever they get a close call, what they do is they modify and perfect their system. This is one of it. The update covers items such as filing deadline, but also adds Rule 28.8. Very subtle, very simple, but bears a huge weight. Remember, according to the Constitution, which established all these entities, the judicial power of the United States shall be vested in one Supreme Court. Think very broad when it comes to international relations, when it comes to treaty, etc., etc. Think very broad and understand this thing called the incorporation doctrine, which we go over that in great details on the Patreon page, and how it ties directly to the 9th and 10th Amendment, which is a deeper aspect of private right of action. But think deeper. If they are adopting this rule, do you not think it's going to slowly come into your state level? Because each state has their own Supreme Court system based on incorporation doctrine. Stop for a moment and think of the importance of system and comprehend what your cause is and whether you need to gather a team to get things done or not. At least have a system and know what your cause is. If you're stepping into a battlefield without really knowing your cause beyond how you feel, and without really having a system, it would lead to more demise. But also adds Rule 28.8, which requires anyone arguing before the court to be a lawyer. A lawyer is someone versed at law, not necessarily an attorney. Another intricate details you need to keep in mind. We just read Rule 28.8 when it speaks about attorneys. In a public notice, they will double speak. Be very careful of the art of double speak now. On the patron page, we also give the details and explanation of doublespeak. The High Court says the new rule simply codifies a long-standing practice of the court, meaning we never really put it in black and white succinctly to say, "Ha, look, that is what we do." But we've been experimenting with it and see if we can get away with it. And when these per se litigants come, we really have a system to really figure this out. And how close are we really getting to really having our system crumble? But before that happens, based on the fact that we've experimented with it, we're not just going to put it in black and white and tell you this is what you have to do. A non-lawyer has not argued before the justice in more than 3 decades, that being 1978, Sam Sloan. Though not for a lack of trying, meaning people have been going in there doing things, but they've been shutting them down. The Supreme Court is one that have final say on the judicial level, and that's constitutional. A magazine publisher, we're not speaking of whether the real constitutional court is in Philadelphia or not, because they can have enclaves, satellite offices. A magazine publisher, entrepreneur, and paralegal in training asked but were turned down. Paralegal in training in the past year. New York resident Samuel H. Sloan, now 68, was the last non-lawyer to do it when he represented himself in 1978 in a lawsuit involving stock trading. Sloan says he interviewed several lawyers who volunteered to represent him for free, just for the prestige of appearing before the court, but he decided to handle the job himself. It wasn't on an ego thing or anything like that. He said recently, "I wanted to win the case. I was convinced I couldn't win the case in any other way but to argue my own case." He won 9-0. Oral arguments is a relatively small part of the case. A relatively small part of the case. Listen to this. Although the justices say it can, on rare occasions, be critical to the outcome. I'm telling you, most of the things people deal with in today's world, when you really, outside of using the dynamics of the formality of the courts, when you begin to see the importance of actually doing certain things on a formal level, on a Supreme Court level, this rare case will be applicable to you and everyone else. More important is the written argument that both sides and other interested parties filed. The justice agreed to hear 2 cases this past term filed by non-lawyers, but this is extremely unusual, and only one of those 2 men wanted to argue himself. Actual argument by non-lawyer is even rarer, and even Supreme Court scholars have a difficult time coming up with other examples beyond Sloan. But it has happened. In 1948, remember 1978 was the last time, but in 1948, a Chicago man named Harrison Parker appeared before the court to argue that he was improperly convicted of contempt of court on 2 different occasions. One newspaper report from the time suggests Parker did fine, though it was clear he was an amateur. He arrived with a thick pile of notes, waved his fingers at the justice, and wore striped pants and a cutaway jacket, meaning etiquette is important. If you comprehend the importance of system and being able to enforce a cause, then you would understand the importance of etiquette. Very important. The majority of the people going on about this pen and paper thing don't care much for etiquette. In fact, they think it's not necessary. When in truth, etiquette is about 50% of what you're going to do to make things work. That was what all lawyers once wore to argue the court. They had fallen out of favor for all but government lawyers by the time Parker appeared before the court. Still, a Washington Post reporter covering the case wrote that Parker proved, quote, "you don't have to have a lawyer in the Supreme Court," unquote. Scholars and lawyers who have appeared frequently before the court, however, say it's a bad idea. Of course they would. The justice wants experienced advocates who know more than the fact of the case and can apply them to other scenarios as well as answer technical questions about the law. Most people who speak up for themselves, pen and paper, formally or informally, they're still struggling with this. And these people are rubbing it in your face. In other words, they just basically told you, we know you all don't know anything about how the world works, which you should. That's one of the things that actually confers the people the power. Competency is power. It really is. But if one just reads something and goes on about the feeling of it, that's dangerous. It will be used against you. If you have not gone to law school and had some experience in court, I would think that would be a very difficult chore, said Chicago lawyer so-and-so, a veteran of 30 arguments before the court, and one of the co-authors of Supreme Court practices. They're rubbing it in people's face. Competency is the key. You don't have to go to law school to be competent. You have to have a system and know what your cause is. They refer to it as stupid and a crazy idea. In 1982, Edward Lawson of California petitioned to argue for himself in a case where he challenged a law that allowed police to stop people and asked them to identify themselves. The stop and frisk, stop and identify laws. And the stop and frisk and stop and identify, which Terry versus Ohio gave birth to, which we went over, regarding it being an extension of the loopholes that they attempt to use to circumvent probable cause requirements. Those Terry stops and frisk stops are implemented directly into specific languages, specific supposed violation of state public laws, session laws, general laws that are later codified as state statutes. So stop and frisk, stop and identify are based on a specific criteria per state. Again, on Patreon page, a video was done showing the list of where stop and frisk and stop and identify is incorporated into each language of each state general laws codified into the statutes. But nonetheless, this guy challenged that in the year 1982. Bear in mind, Terry versus Ohio took place in the late 1960s. The court turned down the request from a 36-year-old entrepreneur and consultant who was the subject of frequent police stops. Lawson later accused the Supreme Court of conspiring with the lawyers in court assigned to argue his side to deprive him of the right to appear on his own behalf. He the first time said, you know what, it's fine, I'll use you just for the purpose of being able to, get into the prestige and access to certain things. Of course, you have to know that other guy, Sam Sloan, was a stock trader, meaning he's into the monetary system. The trade market is no different than the tool that's used to calculate the codes from a car to diagnose the possible problem. The stock market is just another tool used to diagnose the people's ebbs and flows of energy, which, believe it or not, the court system are directly intertwined with it. So when you see that he won 9-0, Sam Sloan, that is, which is the last dude, which is the last man to ever argue on his behalf, to ever invoke due process verbally and back his paperwork with his word without anyone speaking for him. He won 9-0. There's a reason why this looks this good. Read in between the lines. This other guy in 1982 said, well, the guy that spoke on his behalf was basically convinced to do exactly the opposite of his intent. A year later, Hustler magazine publisher Larry Flint fired his lawyer on a libel case before the court and asked to handle argument himself. Flint was also told, quote, no, and the court assigned Shapiro to argue his position. Flint came to the argument but was escorted out when he started yelling obscenities. It's easy to get carried away. You have to comprehend that this thing is a business that they're engaging in, and that business has a system. So you must come in with a system that's based off of a cause. You must know your own cause. And when you do somehow interrelate with their business, you must know how contract law works. You must have communication skills. Even with basic things like these that we go over here or on other venues like Facebook, Instagram, or on Patreon, you wouldn't believe the amount of people that lacks communication skills. People think you owe them something, speak anyhow. The majority of the people out here saying they seek restitution freedom, most of them don't care much for it and the etiquette and the common sense that goes along with it. They're used to just opening their mouth, running their mouth, and just letting their piece loose. And that's even besides the importance of competence. If you really want to find solution, and you're saying you're one of the people, you're going to have to do better because you are held at a very high standard. And you must know the dynamics of how these systems operate and why and how they exist, and how it's necessary for you to create a system for yourself that would properly interface with theirs. You know, class action suits are the exact same way. Whenever people speak of class action suit, see, class action is a retroactive thing that was created to substitute the power of the people. Because class action is supposed to be a group of people who experience the same circumstance, who will now come together to basically state a claim upon which relief can be granted. But class action suits can only be enforced by attorneys. And that class action suit is only created retroactively to the power that the people have to right and grievance and redress. Why aren't any of these people speaking about this? And why do people speaking of class action suit, why don't they look at things from that basic perspective first? Competency. Stephen Allen Levin of Guam was working on his paralegal certification when he petitioned the Supreme Court last year to hear his case involving contract surgery gone wrong. Last year being 2012, because this article was released in 2013. Keep that in mind. When the court agreed to take the case, Levin asked to be his own lawyer at the urging of a supervisor at the Attorney General's office of Guam, where he was working as an intern. He was told no, but said in an email that he pressed the court clerk's office to cite a provision of law or rule that would prevent me from arguing. He says he can't remember getting a reply, and the court ultimately appointed a lawyer to argue his point. When they constantly say the only one that can come and access and do business here is basically what they're saying. When they say the only one that can come and access and do business here is one of our people that we've held harmless and have given permission to do business here. That should tell you automatically that your stipulation on pen and paper should be very straightforward and strict. And whoever is going to appoint have to agree to your contract. Systems are carried by contract. And the way you do it is not by trying to challenge someone or trying to prove a point to someone or trying to speak your piece. While it may not sound appealing to someone's mind listening to this, just know that there are many ways you can effectively get things done. You don't have to kiss someone's butt. You don't necessarily have to bow to them. But when you are competent, calmness but certainty will be your mode of operation. Levin didn't mind. He, quote, never intended to or hoped to represent myself, unquote. He said just to deter long enough for the court to appoint an attorney. Sloan, the last non-lawyer to argue before the court, says it's too bad he will be the last of his kind to argue. The Supreme Court should remain, in principle, open to everyone, he said. Meaning, foundation of the intent of how things are to work. But this same tool, called the United States Constitution, conferred the power to the Supreme Court. Now keep in mind around this same time that it was ratified a little bit after that the Judiciary Act was created to establish the district courts and its enclaves. If the source of that Judiciary Act is this right here, then this also speaks about foundational principles and separation of power. And when people think of separation of power, they think legislative, executive, judicial. No. Besides those three, there is a fourth one. You know how a triangle has three sides? Extend that bottom that is parallel and make it into a triangle without the middle part being parallel. That is exactly the foundational principle of the specific endpoint of this Constitution is. It speaks about three departments of the so-called United States government. And then there's a fourth one, the people. It is often cut off because the people themselves don't know much about what gives them the power to be one of the people. Point in case, The less competent one is, the more one rushes things arbitrarily, the more it damages the original intent that was meant to preserve that thing people think they're running after, which is freedom to speak, freedom to associate, freedom to pursuit of happiness, freedom to due process. These are the basic things that you're dealing with 28.8. These are the basic things that you're dealing with when you talk about attorneys can only come to you. You have the right to associate. But you know that also applies on their part. They're saying we can only associate with you unless you use one of our people to interface with us. Then a negotiator. Court is all about negotiation. You must comprehend it. And another thing they look at is the track record of how you've handled this situation before you even got to the Supreme Court case. That they will not blatantly express it to you, but they are putting all that into the equation. Competency is the key. And this is yet another reminder that your priority should always be competency before you let that fire run about and burn things up. There's a reason why consistently competency is always mentioned here. There's a reason why this page was created. Competency. Remove how you feel about things. Remove that unnecessary fire. Be competent. More importantly, as it's always said, there's more than what meets the eyes about how this reality works. If you think using herbs and roots, if you think using the mind, if you think using animal intelligence, if you think using similitudes and algorithms built into the ebbs and flow of every day through the air, water, sand, and heat, and all the other elements like plasma, if you think all that is far-fetched, some spooky stuff, or some quasi-spirituality, then you are setting yourself and your children up for failure. The least you can do for yourself is adopt some type of spiritual system and remove your feelings out of that spiritual system. Feelings are important. Feelings are the electrical shock that put things to life. But if you don't control that fire called feelings, no matter where you go, no matter how you approach it, your system would not work for you, and their system would always work to your disfavor. Competency in doing things and saying things beyond what meets the eyes is very, very, very important. Just a little reminder. If anyone else is telling you about this, about your right, about one thing or the other, have they told you about how right to association works? Have they told you about the different types of classification of freedom of speech and the different venues that those freedom of speech can be enforced? And what classification is the court venue? Have they told you the standard test and element involved in freedom of speech and freedom of association? Have they expressed to you the exact dynamics and intricate details of how business actually favors you?